Hi, welcome. Good morning, everyone. Welcome to our last panel, the only thing standing between you and lunch. So today, I'm happy to introduce both my colleagues, Mr. Ayato Sakaki, the name correctly, and Mr. Matias Nottinger. My name is Luana. I'm a partner of Montoria Pimenta Machado and Vieira de Mello, and we are discussing strategies for the registration of non-traditional trademarks. As most of you know, this is still, well, we still can find a lot of obstacles for this kind of registration in Brazil, especially since we define trademarks as visually perceptive signs, which already from the start restricts a lot of the non-traditional trademarks. We have been creative for the past few years. We have registered sound as a word. So we put in a word as a sound that supposedly that was not the way to go. We have used figurative trademark institution to register position marks before they were entry. So I'm very excited to see all your tips, all your experience in your respective countries. So I'm going to start with Ayato. So, and I'm sorry, they both have amazing curriculums, so there was no way I have to read. So Mr. Ayato Sakaki is a consul from the Consulate General of Japan in Rio de Janeiro, an IP attaché of the Japan Patent Office. He joined the JPO in 2012, where he had the opportunity to work for the International Cooperation Division and took part in the discussion with WIPO, TM5, and other national IP offices. He also worked on introducing AI technology into figurative trademark searches and conducted the first ever competition at the JPO. In 2023, he was seconded to the Ministry of Foreign Affairs and started to work at the Consulate General of Japan in Rio de Janeiro, which I duly hope that you enjoy the city, as head of the Economic Section, Economic Council, and Intellectual Property Office. So now it's up to you.
So thank you, Laura. Thank you for introducing me, and thank you for inviting me such a nice, great event. I love Porto de Galinhas. So, so today, I'll introduce strategies for registering non-traditional trademarks in Japan. During my time as a trademark examiner, I noticed certain trends in the grounds for refusals. Additionally, I observed some refusals could have been easily avoided at the if the requirements had been known in advance. Although there are many requirements for registering non-traditional trademarks, it is not necessary to be familiar with every single details. To successfully register, it is crucial to be aware of most crucial mistakes. Therefore, I'll focus on the key requirements for non-traditional trademarks and provide you for tips for successful registration. So Laura already introduced me, so I'll shortcut this slide, but I'll add some information. I like running, and I just arrived at Rio de Janeiro. I ran around the beach of Rio de Janeiro, but I like running beach in Porto de Galinhas. Next. So this is my contents of my presentation. Firstly, I'll begin with non-traditional taxation in Japan. And secondly, discuss the crucial points in examination guidelines. And lastly, I'll present case studies. Okay. The first trademark, the Japanese first trademark has been registered 1885. So this mark has already expired, but there is several valid trademarks with a history of 100 years. This well-known mark is registered in 1918. And 3D trademarks is introduced in 1997, and then 2015, sound marks, color pulse marks, position marks, motion marks, and hologram marks, known as non-traditional trademarks, has introduced. And then 2020 revised the regulations for new types of 3D trademarks. The trademark system is vital for business and must be regularly updated to keep pace with emerging business trends. Recently, many companies are employing non-verbal brand messages and variety of branding strategies to set themselves apart from competition. To protect these branding messages and variety of branding strategies, we introduced trademarks. Now let me explain examples of 5 types of non-traditional trademarks. An example of sound mark. Please wait for a moment. So I'll start. Okay. So this is an example of sound mark, and this is the sound mark of Intel. So this is an example of color. Can you guess the name of the light holder? Yes, so the light holder is 7-Eleven. So the 7-Eleven origin is United States, but the number of store is the highest in Japan. Nowadays, 7-Eleven is a well-known mark in Japan. This is an example of position mark. Mark stand for. Yes, it's cup noodle. I like the flavor of feijoada. So this mark is cup noodle, and this is also well-known mark in Japan. So this is an example of motion mark. Can you guess what trademark stands for? So this mark signifies that the toothpaste kills bacteria. This is an example of hologram marks. Can you guess what goods are? Yes, designated goods is sake. So this hologram mark changes with temperature. You know, sake has good temperature for drinking. Observing these hologram marks, you can determine ideal temperature in sake. I like it. These graphics illustrate the number of application and registration. To date, we've accepted over 2,000 applications and registered 758 non-traditional trademarks. This graph displays the percentage of registration. It is evident that sound marks, color marks, and position marks are challenging to register. I'll now explain how to research for non-traditional trademarks in Japan. You can search for the Plat path. Upon accessing the website, select trademark search, and then click the type of trademark. Next, I'll introduce examination guidelines. This is the examination flow. The difference between traditional trademark and non-traditional trademarks are highlighted red cells. To be concise, eligibility and consistency are examined additionally. However, distinctiveness is also crucial for non-traditional trademarks. This table presents formality requirements. Generally, when applying non-traditional trademarks, it is necessary to include a description of trademark in application. For sound mark, you must submit sound file additionally to the application. So let's explain eligibility of color person marks. You must describe color combination in a liner and a color combination linked with distinctive shape or letters is not acceptable as a color person mark. These requirements is how to describe trademark specimen and are considered such a formality requirements. However, it is one of the crucial requirements because amending trademark specimen is not allowed. Eligibility of sound marks. You must describe trademark specimen using a common method like a fiber cells for clear scope of protection. Sound spectrograms and temperature are not acceptable. This is also crucial requirements because amending the trademark specimen is not allowed before after the application has been filed. So this is the first tip for registering non-traditional trademarks in Japan. Please verify the eligibility of the trademark specimen. At the beginning of non-traditional trademark system, we accepted a lot of application, but many applications because of these requirements. So let's move to the consistency between description or sound file and trademark. Trademark specimen and sound file must be consistent. Regarding this requirement, it is possible to amend the sound file only to align with the trademark specimen. Here is an example of examination. So let's listen to the sound file was initially submitted. Can you hear the sound? No. No. Oh, I prepared the sound file. Okay, thank you. Okay, okay. Can you hear? Yes. So it's a sound mark for a house builder. I think you can imagine comfortable and quiet residential area, maybe. However, the file was not consistent with trademark specimen. So examiner decided to change the sound file to align with the trademark specimen. Next is a sound file secondary submitted.
Thank you so
Can you hear? I think a little bit noisy. So even if the applicant didn't want to change trademarks to be registered, the sound file must match to the sound trademark specimen. Next. So this is the second tip. Sorry. This is the second tip for registering non-traditional trademark. Please ensure sound files that match to the trademark specimen. Okay, let's move to distinctiveness of color person marks. Color person marks tend to be refused because of lack of distinctiveness. A color generally lack a natural distinctiveness as a trademark. Therefore, distinctiveness must be acquired through use. In other words, it must acquire a secondary meaning. In Japan, registered color person marks are combinations of multiple colors. The only trademarks shown here are registered as a color person trademarks in Japan. Only these marks. So this is the third tip for registering non-traditional trademarks. For color person marks, please apply for trademarks with combinations of colors that are well known. Okay. Distinctiveness of sound marks. Sound marks with distinctive or sound elements are deemed distinctive. However, non-linguistic sounds generally lack natural distinctiveness, and they must acquire secondary meaning. Here is an example of sound. Can you hear? Okay. Do you know the trademark? I think it is well known as a salon pass. It includes the linguistic elements of hisamitsu. Therefore, it is easier to register. Additionally, if the linguistic elements is distinctive, sharing secondary meaning is not necessary. Salon pass. So this is the fourth tip for registering non-traditional trademark. For sound mark, please apply for sound trademarks containing distinctive linguistic elements. So these are requirements for proving secondary meaning. First, identity of applied trademark and used trademark. Second, identity of designated goods or services and used goods or services. Third, nationwide recognition. So this is the fifth tip for registering non-traditional trademark. To provide secondary meaning, the following must be demonstrated. The applied for trademarks and used trademark are identical. The designated goods or services and the goods or services in use are the same. Nationwide recognition must be required. Let's move to case studies. I'll let you explain cases regarding the distinctiveness. Do you recognize this color mark? It's a trademark of erasers. This was one of the first registered cases of color postmarks in Japan. Initially, the trademark was judged to lack of distinctiveness. However, the applicant demonstrated that it had acquired secondary meaning. Ultimately, concluded that trademark had a secondary meaning and the trademark was registered. The major points supporting the secondary meaning were as follows. Firstly, these three colors, white, blue, white, and blacks, were adapted for the paper strip of mono eraser, introduced in 1969, and have remained unchanged for over 50 years. Even when eraser types expanded, these three are uniformly used based on the specific design rules. Secondly, the designated goods and used goods are the erasers, the same. Thirdly, the trademark, the market share of erasers was the highest, and product usage was nationwide. Not only does applicant conduct large-scale advertising, but third party also feature the products in magazines, newspapers, and so on. Additionally, there was no usage by parties other than the applicants. So this is that case. This is an example of position mark. Can you guess what the mark represents? So it's a controller of PlayStation. Initially, the trademark was judged to lack distinctiveness as consumers might perceive the mark as indicating a type of button shape with decoration of the game controllers. Following the refusal, the applicant argued that the mark had acquired secondary meaning, and finally the examiner decided the mark acquired secondary meaning and the mark was registered. Major points supporting the secondary meaning were as follows. Firstly, the applicant had been using controllers for over 20 years. Although the shapes of controllers has been changed, but the position layout remained the same. Secondly, designated goods and used goods were the same. Thirdly, the market share of TV games was 60% in 2014 and 2015. and applicant over 280 million PlayStation with controllers. In addition, other company offers no other companies offers controllers with this specific position layout. Even controllers sold by companies like Nintendo Wii, Xbox had different button shapes and layout. I'll skip. To summarize my presentation, here are five tips of non-traditional trademarks in Japan. To date, the traditional trademarks from Brazil, if you were to register the non-traditional trademark, you will become the first right holder from Brazil. We urgently await for your challenge. Muito obrigado.
Thank you, Ayato, for this very detailed, very detailed explanation. It was very nice to see all the sounds and everything. Now I'd like to pass the microphone to Mr. Matthias Nottinger. Matthias is an Argentinian lawyer specialized in intellectual property, trademarks, patents, industrial designs, copyrights, data protection, advertising law, image rights, sports law, IP, and related agreements and contracts. He's a partner of an Argentinian firm, Nottinger Armando, and currently the first vice president at AZP and head of the Programming Commission and the AZP Academia program. He was also president of the Argentine Association of Industrial Property Agents between 2020 and 2022, where he also had positions of director, treasurer, and VP. Matthias, now it's with you.
Thank you, Luana. Is okay here? No? ¿Ahí está bien? ¿Aló? ¿Se escucha? No? Channel 4? Okay. Well, Luana, thank you very much for the for your introduction. First, I want to acknowledge the possibility of being here. A big thank to ABPI. I am here representing ACP, and we very much appreciate the possibility, the parceria we have with ABPI of interacting, of exchanging activities, and we really want to enhance this and to reach the Brazilian professionals and welcome them to be part of ACP and to extend this collaboration between the associations. Well, that being said, I want to focus on when I first received the proposal to participate in this panel. I didn't focus, or I didn't see the main part, which is non-traditional trademarks. I really saw the term strategy, because I mean, I said I will want to focus on strategy. So I'm not going to give you also a lot of information about like types of non-traditional trademarks. Ayato made a very good presentation, but I will focus more on strategy. And I was thinking, when I first started practicing, a long time ago in another galaxy, the non-traditional trademarks started to appear, no? And we were used to, like marks and designs and very, very simple type of trademarks. And then I think with the advance of technology, with the need to protect additional features of the client's products and services, we had to be creative and obtain markets to get the protection the clients needed to act or to take action against competitors. And that's one of the basic, I think, concepts is why do we suggest to register non-traditional trademarks? Why did we, as advisors, as trademark lawyers, heard the clients and created these possibilities of registering different type of trademarks to protect different type of different products, features, and distinctive elements? And I think the basic thing, it's because the product a certain presence in the market. The mark is known. The mark has something to protect with the consumers. So I think that one basic thing is that you need to look at the marks when the client brings the problem, but always looking to the consumers and always looking the presence that the client has in your specific market. I don't believe in general strategies where you register non-traditional trademarks, for example, a smell mark or a position mark, etc., in a market that you have no presence, you have very little presence, you have a so I think this is basic because and that's why we see I think America there are not a lot of non-traditional trademarks because in general I think that it's not the knowledge or the possibility of protecting features of the client's products is not so developed. And a clear example is Ayato's presentation in Japan. I think that the companies are very, I mean, it's a very competitive market and the companies tend to use all the tools they have to gain competitive advantage, to get the client's attention and to get in touch with the client's emotions, and you sell the product with the five senses, I think. But in a such a competitive, that's why we see that they have so many non-traditional trademarks. And now, I mean, with the change in the Japanese law in 2015, I believe all these guidelines, these proceedings to get the protection you need. And fortunately, Latin America, and I will move forward. I mean, the criteria are not very. I mean, we don't have that much experience, that many guidelines to protect non-traditional trademarks. But let's go to the challenges. I think. Basically, the main challenge I think is the graphical representation of the marks. So many of these non-traditional trademarks, they present as a challenge of how do we represent them for publication purposes. And this is a key element because the examiners always want to see how the mark is perceived when you publish it and what they are granting, what rights they are granting. So you need to describe it and be able to publish it in a bulletin, for example. And what is remarkable is that sometimes the regulations on for example, of the guidelines of how to proceed, of how a trademark is prosecuted, come first, and then the law. I mean, the law. So sometimes you don't get recognition because you cannot get you cannot express exactly what scope of protection is in a graphical reproduction of the mark, and so you don't get recognition of a certain sign that really deserves to be a trademark. So moving forward, I received a CP's trademark committee is doing an interactive map of the protection of traditional trademarks in Latin America. There may be, I mean, if you're from a country which is mentioned here and the information is not 100% accurate, please, we requested information from associates from each country, and it may be, I mean, you may have a different opinion on what is here. Luana told me that, for example, that color pro se in Brazil, they're green and it's not, it should be red. So color pro se Brazil should be red. Don't come at me. So apologies. But in general, you see that it's pretty green. This is because I think the the legislations are pretty broad in the type of trademarks they allow. Either because they have been changed recently and they allow specifically allow sound trademarks, smell trademarks, position trademarks, 3D trademarks, etc. And in other cases, Argentina is because the definition of trademarks was so broad in 1981 that it allowed us to argue for the registrability of this type of trademark. So let me give you some details. For example, three-dimensional trademarks. I will move forward. Three-dimensional trademark shape marks are the most common in I think in Latin America, and most of the countries you are able to register all these shapes, all these 3D shapes. Some of them may require some sort of proof of secondary meaning or acquired distinctiveness, with, always an important thing. And I go back to the first thing I said. Always, if you have if you have a product that has a presence in the market, it's always much easier protection for a non-traditional trademarks. In this case, a shape. And many countries will require you to show that the product is known in the market and you are not going from zero. You're not asking from zero to get the recognition of a trademark. Then I will show some examples. Color per se or single color so possible sometimes in terms of color combination without being applied to a certain part of the mark. But in general, of most legislations ask that the product not only is the color combination or single color, but also is applied to a certain shape or certain part of the trademark. And you see the one in Argentina, the combination of blue and yellow. You maybe you recognize that what that is. I don't like that you recognize it, but because I'm from River, but and there's a very interesting case, and I think this has to do with strategy. Believe it or not, back in like early 1990s, Boca Juniors filed an application to register the color combination of their jersey, but in the jersey, not like that, in the jersey. And it was refused by the trademark office. I don't know why, but it was refused. They said it wasn't distinctive or whatever. So Boca Juniors went and sued the INPI, the trademark office, and they got such a good decision in court that I believe that it was key, that decision, for them to get this type of protection for color per se. Not only that, but also it was cited in many decisions afterward, in counterfeiting decisions, in cases against media. I mean, Boca Juniors used that decision in many, and today they use it. And basically the judge said, for example, it's funny the wording, but it said even my grandmother knows that is the Boca Juniors shirt. So it says there's no one in Argentina that doesn't know that color combination in a jersey is Boca Juniors. I don't like to talk about this again, but it's a very good example, not only of secondary meaning, but also that sometimes going to court and getting a good decision for this type of trademarks, for any trademarks, but for this type of trademarks, in cases against third parties, when you try to enforce the rights, or when someone says that I mean, you get the recognition, you get the well-known recognition, and I think it's very important. Texture marks are also a possibility. I think that as long as this is an example in Colombia and Ecuador, and the interesting thing about texture marks, especially and someone, Martin will correct me if I'm wrong, but in the Andean communities, that you are allowed, but you also need very detailed description of the type of texture, etc. Of not only showing the texture which you see there, but also describing what the texture is and what you are protecting in detail. And this is always the case, I think. Um, Sound marks, smell marks, etc., texture marks, motion marks. Always you need to describe as detailed and as clear as possible which is the scope of protection. And of course, the criteria among the countries are very different. So in a smell trademark, I mean, of course, you cannot publish it, you cannot represent it. I mean, it's difficult to represent it graphically, so you need to describe it. And when you describe, some countries will say the description is enough. I will grant you the smell of fresh grass, for example, for tennis balls, as the example that we all know from many years ago, or the smell of oranges applied to oil, for car oil, because and the criteria there is it distinctive enough? Is it generic? I mean, is it not the smell of the product per se, of the components? And some countries they will say that that's not enough, and they won't grant you I think a trademark. I think Colombia is the case that they have refused a few. That's what I read in the report I mentioned. They have refused a few scent trademarks because they were not described enough. You were taking a certain feature, a certain possibility from the competitors. So I think that sometimes the trademark offices are more restrictive with this type of trademarks because they sometimes they say that they are taking certain elements from the market, from the possibility of the other competitors to use them, and this is not okay. I think that as long as, of course, as the scent you are describing for the most, it's not the scent of the product inside. I think it's and it's. I mean, it has no connection with the product. I think it's really registrable. However, of course, if you have if you do have acquired distinctiveness, the possibility of showing that the product is in the market, you will be able to have a higher success rate. So let me go to a couple of cases I had and that I think are interesting. These are in 1997. We got a request from L'Oreal to file 6 scent trademarks, and I mean, when I saw them, I said, "There's no way it is go through," because they were like the scent of damasco or banana or cherry or sandia or uva applied to a shampoo bottle. That was it. That was the description. Of course, we got a refusal. But we also had an opposition, and the opposition was the best thing that happened to us because, of course, when the time came, we had to sue the opponent, and the opponent did not respond. So we ended up, litigating with no opponent. The judge was very. I mean, and we of course argued at that time the case about the grass smell in the tennis balls and all the examples, the raw and how the new technologies and the new product features needed this type of protection, and that was a criteria that was in the entire world. The trend was that to give protection to these non-traditional trademarks. And the judge took our argument, cited several cases from other countries, because of course we didn't have case law like this in Argentina. And he said, I mean, the mark is, I think, registrable. However, it's too broad. You cannot, get sandia smell only for you. So they requested us to amend the trademark to show more details about what are the components of the smell. Except for the banana melon, which was a combination of 2, and they said, well, that's okay. But once there were a single fruit, they asked us to put more detail about the components of the smell. So we did that, and the marks, of course, were granted because the trademark office could not refuse them once we had a favorable judge decision. And I think and another interesting point is that the trademark office never allows you to change the mark from the original filing. So you file the mark, it's published, and you cannot change it. By case, because it had a court decision, they had to do it. And this is another thing that I wanted to show in terms of protection of traders. I mean, we represent a complex, a cinema complex, and they were negotiating a license, and they built a new complex, and the owner of the complex, when they were already about to, I mean, they were already with construction, etc. They said, we don't want to, so we will not respect the contract. What as all our features, all our trade dress. Allá no cambió. Allá cambió. That's why you didn't see one. Well, that's if you want to look in the back, that's basically that's not that. I mean, you don't, but that's and that shows the carpets. So I said to the client, send me all the pictures you can send me of the hallways, the walls, everything about the complex, because we will need to build a case that may allow us to obtain an short when the time comes, and if these people use your distinctive elements in this complex. And so in the end, they ended up, agreeing, and the complex went. But this is one, maybe some strategies. And of course, we all know that getting a registration, a trademark registration, it's important when we need to enforce the rights. And this is, and I will end up with these two very, very basic remarks. First, secondary meaning basic in any non-traditional trademark. Very important to get all the information, all the proof you need. If you need to do surveys, it's worth it, especially if it's an important trademark and you are looking for that recognizes that possibility. I know that in Brazil you have the possibility of having a specific recognition of well-known trademarks, but in many countries we don't have that possibility. It's only through court's decisions, or trademark office decisions. So I think it's whenever you can get the chance of getting a decision saying that your trademark has acquired distinctiveness because it has a presence in the market, this I mean, through like a commercial effort from your side, a promotional investment, I think you should always take it. I think I saw many examples, as I told you, with Boca Juniors, that a good decision is the thing that got happen to client to your client's trademark. And then I want to finish with I mean, don't be afraid of the judicial recognition to go into to the courts. I think that either by suing the trademark office or an opponent or a competitor, I think that not only you can obviously enforce your trademark in your non-traditional trademarks or these innovative features that your product has, even if you don't get a recognition by the trademark office. Of course, unfair competition actions. I'm sure in Brazil, when you have this type of problems, you go for unfair competition or copyright. I think now many companies are going through using blockchain to protect certain features of their product, or certain designs, or certain elements. So you can do it very easily and very consistently, and you can leave them there. You know that it has a date, and you deposited this in which you had this, and you can, of course, later, if you get copied, you can use it as proof. So I think I will wrap it up there to leave a few minutes for questions or remarks. I see colleagues from all over the region, so I'm sure they, if you want to share some of your experiences, please, if gave incorrect information, don't don't say it out loud. So I, I I I will wait to get my own applause. Thank you.
Thank you, Matthias. Interested to see both of you speak about secondary meaning. We use in Brazil more in the litigation, in litigation cases. And of course, we do have a research that's mandatory, as you said, for well-known trademarks. But it's very nice to see you using for non-traditional trademarks, even in an administrative level. And I believe Ayato said that it's mandatory for sound and color per se as well. And I'd like to know that you can use for other things. I know that I have questions, but since we only have 8 minutes, I'd like to open the floor to see if we have, of course. So I'm not using my power as a moderator. I'll wait, and if I have the time. So thank you.
Hi. Yes, guys. Yay! Thank you. Thank you for this amazing panel. I am Cristina from Guatemala, and I want to ask the panelists, but also here in the public, because I can see that we have many from INPI. So, what do you think about secondary meaning? Would I be able to convince the examiners based on social media? Like I would say, I have so many followers on Instagram and on Facebook, and they follow me. And would that be enough? Like, or would be a criteria that I would apply to? And that would convince you as an examiner? I want to know all of the opinions from both the panelists and anyone here from INPI. Because as Matias showed, in Guatemala, it was correct. I confirm. I confirm that Guatemala has doesn't allow color marks. It's a refusal. It's a ground for refusal. Is an absolute grounds for refusal, but you can apply for it based on secondary meaning. So, how does social media work here? Thank you.
Testing, testing, testing.
Thank you for question. I think you have, I can imagine lot of followers for Instagrams or Facebooks, SNS. So in terms of SNS for proving secondary meaning, I think it is possible to prove the But my voice? Okay. So SNS is possible to become evidence of proving secondary meaning, but I think the amount of SNS, amount of evidence is required because SNS is need to change. Yes. So if you want to prove secondary meaning by SNS, you should submit a lot of evidence. So thank you so much.
I say that it applies to any type of promotional material, and I think obviously social media is a very current, a very, very important part of our society now and the way we communicate. So, of course, as Ayato said, probably you need to, if you want to show that you were using or certain elements, you need to prove that, because it's so dynamic that probably what you upload now, it's tomorrow or etc. So the contents are very dynamic. But another thing I think I want to say about secondary meaning is sometimes we and our clients have a perception of their product or of the product's fame that sometimes it's distorted, but because you're biased. You think your product is number one, oh, this is very well known, and then you go to the examiner and says, what's the product? I don't know it. You're asking to us, I mean, you believe you're well known, but the evidence is not, and the judges, I think, or the examiners are sometimes incorrectly, they are biased by their own perception. So if they don't know the product, they say, well, what's the evidence? But I had never heard of this product. So if the examiner or the judge never heard of a product, well, or certain features of a product, well, maybe they said, well, it's not as well known as you think. So we see that a lot. So I think we need to be cautious when we tell a client that their product or recognize that there's a secondary meaning or the possibility of acquiring distinctiveness or of course of the protection of a well-known trademark. You want to go for a well-known trademark. That's my opinion. Thank you.
I think we have another question there. Two. So, the mics. First, second, and I think unfortunately that's it because we have 3 minutes, but the two.
Alô, vou aproveitar porque vou responder a pergunta, inclusive.
I will answer the question. Yesterday, I watched the panel regarding distinctiveness that is acquired in the project. We didn't accept so far, but next year we will implement the recognition of the distinctiveness acquired, and this year we will have a public consultation, more or less by October. So you are all invited to participate and having the means to have this recognized. And we have a panel that is recorded that happened yesterday and was 100% online.
Hi, good morning. Congratulations for the panel. I think it was very, very illustrative to know about your practice in our countries. It's good to know that the Brazilian Patent Office is going to definitely adopt the secondary meaning doctrine. I think that will improve a lot our practice. And although our law, our IP statute still does not have the acquired distinctiveness provision, we know that we have some precedents, some very, very interesting precedents here in Brazil. I can mention like the Lobotan case, and also some case dealing with the trade dress of the Brazilian uniform of the national team. The Court of Appeals of Rio de Janeiro has already recognized the secondary meaning in the uniform. Speaking about football teams, I'd like to know the Argentinian experience, Matias. If you could share with us some case dealing with Boca Juniors or River Plate. Do you have precedents involving the trade dress or the uniform of those teams recognizing secondary meaning? So if you could share, your experience in respect to the football teams and also examples that you can mention, that would be great.
I mean, the most cases I saw were involved Boca Juniors, because as I said, this decision that was around 20 years ago, with Boca suing the trademark office and getting this decision about the well-known, not only of the color combination in the T-shirt, but the color combination per se. So then they used this to, for example, they sued a publication and which used it's called Boca Juniors against the Editorial Atlante, a special magazine, and since the magazine combined the two colors, they got a trademark infringement decision. Of course, there were copyright issues and other issues involved, but again, they said, well, the combination, the color combination. They also got a decision against blankets, like not blankets, to bedwear that were, they were using the color combination, and they were sort of like pretending that they had like a license, but without license. And of course, there was an official licensee with bedwear for Boca Juniors, so they went that. So to my knowledge, Boca is a club that has done most of the trade dress cases and has. I mean, they didn't win every time, but they have quite a number of favorable decisions, recognizing the distinctive capacity of the blue and yellow colors. Of course, always has to be in context, because it's not that I mean, you cannot sell blankets that are, or bedwear that it's yellow and blue. But in general, I mean, the cases involved not only the color combination, but also some sort of commercial that sort of gave the idea that has some sort of connection with the club, or had some sort of license or official authorization to market. But I can send you if you want, I can send you the cases if you.
So I'm sorry if there were more questions, but we are out of time, so I had to wrap it up. Thank you, Ayato. Thank you, Matias, for the great presentations. Thank you all for being here this morning and for engaging. And let's enjoy our last day of BPI here and have a nice lunch, everyone.